In 2017, the government began making efforts to convert the employment status of workers in the public sector from non-regular to regular in order to ease the duality of the labour market. So, is this possible in the private sector? To convert non-regular workers into regular workers in the private sector, an environment must be created in which firms are encouraged to take the initiative. Accordingly, KDI conducted an analysis on the impact of the Non-Regular Employment Protection Law in 2007 on the employment decisions of the private firms. Since the enactment of the Non-Regular Employment Protection Law, firms are obligated to convert fixed-term workers to non-fixed-term after 2 years. Firms are also prohibited from discriminating against fixed-term workers. So, what has happened to the employment in firms? Despite an increase in the share of regular workers, there has been a decline in total employment, while the use of other non-regular workers, not protected by the law, such as contract workers, has also increased. In addition, firms without a labour union experienced a relatively large increase in the number of regular workers, while those with a union saw a marked rise in that of other non-regular workers. Then, what are the thoughts of the firms themselves regarding the regulations? KDI questioned the CEOs of 1,000 randomly selected firms about their intentions to convert the status of fixed-term workers to non-fixed-term or regular, as well as their treatment of them. The survey was then analysed according to firm characteristics, such as difficulties in amending working conditions, number of employees, labour union, work complexity, etc. With all other variables constant, the analysis found that firms that had more difficulties in amending working conditions, including wages, working hours and welfare, were more unfavourable towards converting to regular status and to equal treatment. Also, when variables such as difficulties in amending working conditions were controlled, the presence of labour union had no significance in the conversion and fair treatment of non-regular workers. This implies that perceptions about amending working conditions has more bearing than whether there is a labour union.
그간의 비정규직 정책은 비정규직 사용의 법적 규제에 주로 초점이 맞춰져 있었습니다. 이러한 법적 규제만으로는 고용 형태별 이중 구조를 해소하기 어렵고 오히려 실업 및 외주화를 증가시킬 수 있습니다.
전통적인 노동 유연성의 개념을 고용에서 임금, 근로시간 등 근로조건으로 전환해 근로자에게 필요한 일자리의 안정성과 기업에게 필요한 인력 운영의 유연성을 균형 있게 추구해야 합니다.